Hello, welcome. Today, we're going to be checking in on a hearing that Courtney Clenny in Miami-Dade County had with her attorneys and the prosecution on Thursday, May 22nd, in, as I said, Miami-Dade County. She's up for charges of murder. In this case, we haven't heard a lot about it lately because it's kind of been in the stasis. There was, if you'll remember, charges pressed against Courtney Clenny and her parents for withholding the evidence of a laptop presumed to belong to the victim, Osama bin Laden, and they actually dropped those charges based on the having the password and all from Courtney, actually that it was in the house at the time that it was turned over. But because they had access to the personal emails and all of the parents in regards to conversations with the attorneys in regards to Courtney Clenny's case, there was a violation by the prosecution for attorney-client privilege. And that was settled by the judge already. And she said that the actual prosecutor who accessed that could be subpoenaed to testify. And since then, he has withdrawn from the case because it would be a conflict of interest. Now, we're going to address the rest of it because from what I have read recently is that the attorneys for Courtney Clenny are pressing that the entire Miami-Dade County prosecution office be removed from the case. That is too prejudicial for them all to stay there based on the violations of the reading of attorney-client privilege when the laptop was seized and having access to the iCloud information. Even though the prosecutor involved has recused himself and stepped down from it and has no access, they now want to remove the whole department. And so, well, let's check in with them.
So are we ready to go? We have defense counsel here, state here, defendant is present. You guys ready to go?
Yes, Judge. Sean Abuhoff on behalf of the state, along with Kathleen Hope.
And Frank Prieto on behalf of Ms. Clenny. She's present before the court, and also co-counsel Ms. Pugliese.
So we are here for defendant's motion or amended motion to disqualify the state attorney's office. I was able to get through a lot of the binder. I've obviously looked through the motions, the response, and some of the case law, but we're ready to go. So defense.
Yes, Judge, you have the binder. I know you've read it.
I haven't read through all of it.
Okay.
That dropped off a day in advance, but I have to
Sure.
read through a lot of it.
Sure. And Judge, our written pleadings say a lot. And so I don't think this oral argument has to repeat everything that's already been delineated in our amended motion and especially in the reply. So I'm just going to highlight some things for you. So the standard is...
So for the standard and why you believe you've met the standard and...
Yeah, so the standard to disqualify the state attorney's office is found in Downs versus Moore. And that is the defendant must show substantial misconduct or actual prejudice. And the case law that interprets what actual prejudice means is more than just an appearance of impropriety. But in the reply, in the state's response to our motion, they're highlighting most of their conduct that they've done after what I would refer to as the misconduct of ASA 20. The court is intimately familiar with those facts. You send the deposition, so I don't need to rehash facts of that particular breach into the defense camp. What the state argues is that look at everything that we've done since. We've sealed the V case off. We've restricted access. I would just note that Mr. Quinn's still on the delivery list for pleadings, but we unclick him to kind of wall him off. But what I think is most important, Judge, is Mr. Abuhoff and Ms. Hope. It's not what they did, Judge. It's what they didn't do. And what they didn't do, which is contained, I believe it's Exhibit A to our motion. Yes, it's Exhibit A. We have a letter As soon as we realized upon the arrest of Courtney Clenny's parents and the allegations contained within the arrest warrant, it was clear that the state had obtained our work product or attorney-client privilege communications. As recommended by the Florida Bar, as soon as we realized that they were in possession of our confidential communications, we sent a letter addressed to Chief Assistant Kathleen Hogue, Sean Abahoff, and Mr. Quinnen. That first letter was February 15th of 2023. The response to it was sent via email. The response we received from the state was complete silence. They didn't even acknowledge receiving this. Exhibit B, another letter shortly thereafter, February 28th, 2024, same letter, second request. That was received, sent out via email, and the response to that request for having our confidential privileged documents back or communications was silence. Exhibit C, third request. This one came February 10 of 2025. That was after the Chapter 119 revealed the email, the confidential privileged email. We sent the third request again. Ms. Hogue, Mr. Abahoff, Mr. Quinnen. This third request for our work product and confidential communications again met with silence. So why is that important? The case law that we've talked about in the written submissions talks about substantial misconduct. And what does that mean? The case law doesn't say exactly what that means, but what the case law does say, every case needs to be looked at on a case-by-case basis. So we have to look at the facts of what has occurred in this litigation, and the appellate courts, again, would review that on a case-by-case basis, because every misconduct it would, I think, be different. So what we have here is, again, the court's very aware of Mr. Quinnen's misconduct, but Mr. Abahoff and Ms. Hogue, they had a responsibility. When they received these letters, they should have said, you know what, Frank, Sabrina, let's look into this. What exactly is it that you think that we have? They didn't do anything. So I believe their misconduct is by omission, which I think the court should consider in combination with the misconduct of the ASA Quinnen in reviewing those materials, not disclosing that to the court, which is it's not a two-prong analysis. It's substantial misconduct or it's not and. And what the state relies on is the actual prejudice. They're saying, hey, she hasn't been prejudiced. Nobody else has seen this stuff. But I think the analysis that we think is important for the court to consider is, does the conduct of the state by acts or omissions rise to the level of substantial misconduct? And I think it has. They had an opportunity to do the right thing when they received our correspondence. Hey, let me investigate this. What are they talking about? Let's talk to Quinnen and figure this out. Because if there was something done that was improper, they could have nipped it in the bud right there. And they didn't. So I think it's the combination again, the acts and then the omissions on the part of the state. And I think it rises to the level of substantial misconduct. The appellate court decisions, one that the state talks about is Nunez. We think this case is more similar to that of Martinez versus state, where ASAs heard jail calls between the attorney and the client. And in that case, in the Martinez case, the third district, I think it was the third district case. Fourth. In that particular case, that was affirmed on appeal. So it really is very unique circumstances that we're in. I haven't litigated a case of motion either on the side of the state or defense now 25 years. So it's an interesting topic. But I think that what occurred here, Judge, it's an abuse of discretion standard. I think there's substantial record evidence of what occurred and what should have occurred or didn't occur that would support, Your Honor, disqualifying the entire office And that's what the defense is asking. The entire Miami-Dade State Attorney's Office should be disqualified.
Right, state.
Yes, Judge. So it's the state's position that the defense is misinterpreting the law on this issue. The defense wants to separate substantial misconduct or actual prejudice. But I think the case law is very clear, and there's a reason why quotations only appear around actual prejudice after the term substantial misconduct. And I think that's meant to define. There's a reason why in all of this, the case law on this issue, it only goes on to elaborate on this actual prejudice and what it is, and not just the mere appearance of impropriety. So that's the major part here. And if you look at all the cases that even the defense cites to, they all come about by some form of misconduct by the state. And the question just comes, does it rise to the level of substantial misconduct? And the analysis all comes down to, is there actual prejudice by the defendant at the time? And is there a fear of potential future risk of prejudice? So I think that's the analysis. And I think the defense, certainly wants to look at this individually and point to just substantial misconduct without a definition, whereas all the case law gives it to us. And when you look at those cases, there are plenty of them that are similar to this. You look at McWaters v. State, that the defense side of the Florida Supreme Court 2010. That's where the state actually even listened to jail calls between the attorneys and their client. So there's some form of misconduct that far exceeds what this can even be, but that's part of this analysis. And we have to look to and break down both who are the actors, and what is the prejudice that the defendant faces. And the question here is, does the defendant face prejudice right now in the position that she's in, with Ms. Hogue and myself remaining on the case? And then if that is actually true, then the question would then move to the office as a whole. So I can take, and I would argue, Your Honor, that she does not face any prejudice, and we can break down the two breaches that Your Honor has found to be breaches. The first being the text communications. And defense points to these letters that they've sent to us, the February 15th and February 28th, 2023 letters that were received with silence. That's because after this all came about, we had all of this litigation on the issues of whether or not it was protected material on that computer case, that access case. Your Honor took control of those drives, and it's been in your possession ever since. So the idea of being able to turn back over these items, they were not in our possession. So I don't think we can be faulted for not responding to their letters. The content of those letters are important, though. And that's why McWaters becomes an important case, because in that case, in denying the motion for sanctions or disqualification, the court found that there's no evidence that the substance of these calls provided any benefit to the prosecution or were used in a way that detrimented the defendant. So McWaters goes on to explain that when you look at the context of those communications, there was no detriment to the defendant at that time or any future risk, because the calls were what they were. These communications, the only person who reviewed them was Mr. Quinn in their original format. The world has had an opportunity to review them in the arrest warrant and in the search warrants. And what is clear is that those are just discussing the access of the computers. So there's no prejudicial information within those text messages that either myself or Ms. Hogue have seen, or really anybody in the world has seen. And through Mr. Quinn's deposition, he did not even see it. It was limited to just that. So from the context of just the communications of those text messages, there's no work product, or I should say no defense theory of the case. There's no strategy concerning the homicide prosecution itself. It merely is the access of this computer. That being said, again, myself and Ms. Hogue did not access this. So as we sit here today, there is no actual prejudice that the defendant faces. It cannot, I don't even believe it rises to the level of an appearance of impropriety, but that, even if it did, that is not enough. But I think the analysis really, and the harder question here is now moving to that, and I termed it in my motion, the Puglisi email. What's clear is that no one that is currently on the state's prosecution team had an opportunity to review this. Mr. Quinn himself did not remember this item. Because when Your Honor ordered every part of the communications turned over to you, this would have been included. This is part of that. This doesn't come about until there is a public record request. And that is when the defense sends us, once they're made aware of it, they send us a letter to have us turn it over. Again, it's met with silence because we don't need to respond to it, but we do take action in it. And that's the importance. Myself, Ms. Hogue, has come before this court and stated that we have not viewed it, and we don't plan to view it. And I don't believe anybody in our office could ever view it because I've been able to verify it has been deleted from our servers. So the only person who accessed this is Mr. Quinnen. And in his deposition, what was clear from that was the only thing that he remembered from it was the name Mr. Haas, which was their computer expert. And again, going towards that investigation, that separate matter. So when you look at that, that is the Nunez case very specifically. It is a person who accessed, an individual who accessed attorney-client information and the contents, and we have no problem with stipulating that the contents would be prejudicial if the state reviewed it. Mr. Quinnen does not remember the contents of it. His only knowledge based on the deposition is the Mr. Haas aspect of it. And so he's also stated in that deposition, we've affirmed he has not discussed with anybody in the state attorney's office the contents of that document. So that goes to the Nunez case, which in that case they found, based on what the court deemed as misconduct, did not rise to the level of substantial misconduct for the office. It did for that prosecutor. They removed that prosecutor, but not the office. So that's why this is not State v. Martinez. In that instance, that prosecutor, not only that prosecutor, other prosecutors heard the calls and were discussing throughout the office. The state has done its proactive work to ensure that the rights of the defendant aren't violated, that the defense team's communications aren't overheard, and we have a filter protocol in place for all of this. Your Honor has been made aware that once and if Your Honor rules to not disqualify us, we have someone coming to receive these drives to ensure that that is all filtered out. We have no issue with allowing the defense to review those drives prior to any of the prosecution team, or certainly the court, if Your Honor wants to review them. We have no issue with doing that. And I think that's the appropriate thing now that we're here where we are. So we can ensure that there are no more of those text communications that can be reviewed. Concerning this document itself, again, it's been wiped from our servers. No one can access it, and I've been able to verify that. So that's why this does not go to the State v. Martinez case, and this is the Nunez case. Bless you. The other part is that Mr. Quinnen has been screened off the case, and that's why I created the analogy of this is different from the Popjoy case, which is a third DCA case from 1992. That case, the office that was taken off of the case, too small to be able to handle that situation. And so the dissemination of information was inevitable. That's not what this is. The Miami-Dade State Attorney's Office is one of the largest in the country, one of the largest in the state of Florida, possibly the largest in the state of Florida. We were able to screen Mr. Quinnen to where he doesn't have access to the electronic file. He doesn't have access to the hard file. He doesn't have access to myself or Ms. Hogue. And actually his office is on the far reaches of the state attorney's office to where we don't have to interact with him. So we're able to ensure that anything that he has seen, which the deposition shows that there really isn't any prejudicial information, would not come about or would be discussed with the current prosecution team. So that screening process is an important part and why there is no risk of future prejudice that the defendant might face. So, Your Honor, based on the arguments that I'm making, as the defendant sits here now, based on what Your Honor has deemed breaches, two separate breaches, or one separate breach, but two separate items, there is no actual prejudice as she sits here now with the current prosecution team, let alone the office itself. And then the risk of any future potential breaches or prejudice, we believe that we've taken proactive measures to ensure that that will not be a concern for this court or the defense team.
Yes. Your Honor, it's, how can I put this? The credibility of the testimony by Mr. Quinnen that he just forgot. Right? He forgot discovering the linchpin, the evidence that he needed to find the laptop, locate our expert. That is just that Your Honor can evaluate the credibility of those statements. What the state is trying, and just let's talk more about what occurred. Mr. Quinnen disseminated that information to law enforcement. His testimony was he didn't disseminate it to anybody else in the office. We know that the copy of that email was on the servers, but I do believe, and I do not doubt Ms. Hogue and Mr. Abhoff's representations to the court that they did not view it. But going back, the state's arguing that it's substantial misconduct has to have actual prejudice, but it's an or. And the quotes, I would say, are because the Downs versus Moore doesn't say prejudice. It says actual prejudice. That's the distinction of the quotes. It's an or situation. So for that substantial misconduct, we have to look at what the conduct was of Mr. Quinnen, and then again, the omissions, I believe, on the part of the two prosecutors. In the case of Nespler, which I think the state and the defense have argued in our written pleadings, I guess that's the beauty of the law. We're almost citing the exact same cases, but interpreting them differently. And then Your Honor has to figure out that who's wrong and who's right in a somewhat of a gray area. But Nespler, that's spelled with a K-N-E-S-P-L-E-R versus State 314 Southern 3rd 287. That's a 3rd district case. And they cite to one of kind of the staple Supreme Court cases that addresses this issue, which is State versus Fitzpatrick 464 SO2D 1185, Florida 1985. So they talk about how the state is different than a law office. And they say there's a distinction between private law firms and government prosecutorial offices, and that's citing State versus Fitzpatrick. So as a result of that distinction, the Florida Supreme Court has recited that imputed disqualification of the entire attorney's office is unnecessary, meaning you can't do it or you shouldn't do it, when the record establishes that the disqualified attorney, who I would say here is Mr. Quinnen, right, has neither, one, provided prejudicial information relating to the pending criminal charge, which I think that's a tough sell, nor, meaning, and he also has not personally assisted in any capacity in the prosecution of the charge. Mr. Quinnen clearly, right, personally assisted in a whole bunch of capacities, right, in the prosecution of the charge. And again, that's, so what, why is disqualification of the entire office appropriate? Because he, Mr. Quinnen, personally assisted in any capacity in the prosecution of the charge. And that's at 1188 in the Fitzpatrick case. So, you know, we always, when I was in county court and we were all, you know, in county court, the judges, when it's DUI Mondays, there's the state, oh, judge, this isn't my case. This is, I say, so where's he? He's in the hallway, right? Well, you are fungible. That's what we used to always get. Well, you're fungible. You can go ahead and try this case, Mr. Prieto. So it's that distinction. The state is kind of considered their one fungible body. And that's what Fitzpatrick talks about, is that if I believe it stands for the proposition that if the attorney that was disqualified participated in the case, that's it. You can do it. Right? So I think if you look at you know, the totality of the circumstances of the misconduct by act or omission, I think that your Honor would be on solid ground in the third if you disqualify the entire office.
Judge, if I could just clarification, no argument. For the disseminated to law enforcement, that Mr. Quinnen, that was only specifically those law enforcement officers were on the computer case, is my understanding. And if defense knows otherwise, I believe it's just the.
I believe that's correct. Yes,
right. So that's a different department than prosecuting the homicide. So I think that is also important to note because that's also other screening that can take place that there has not been discussions with those officers as that case no longer exists. And the only other part would be that the Nespler case is a third DCA case that comes after the Nunez case, and Nespler does not discuss the Nunez case or call into question the Nunez ruling.
Judge, I do appreciate the state has tucked away Mr. Quinnen in the far reaches of the office.
He's stuck there before.
Yeah, well, we have to rely that he's not going to speak to anybody. And I think that that's the fear that the client has and we have as a defense team that there's nothing to stop the state from, well, we'll end it there, Judge. I appreciate the court's time and the hearing and
Right.
appreciate the state's arguments.
That's for transcript. I think I took all the notes. Let me set it for my ruling. I want to go. It's going to take me a little while to go through everything to write it all out. So let's get 30 days. Then we'll decide. Okay.
Thank you, Judge.
Thank you, Judge.
Be like a status.
I'm going to do 30 days to my ruling.
Okay.
So would you like to do July 23rd? It'll be a Wednesday.
No, let's do June.
June. I'm sorry, Wednesday. Tuesday. June 20. I'm sorry, Wednesday. Tuesday. June 20.
23rd might be on Monday too.
Yeah, it is.
June 25th is a Wednesday.
Okay, let's do Wednesday. Yeah,
June 25th.
sounds good. All right.
All right, there you go. I just wanted to make sure that we got the audio in of the scheduling of the next hearing, which would be June 25th, the Wednesday.
I'm logging off of Zoom for everybody who's
Okay. All right. There we go. I just wanted to wait a moment until she finished scheduling the next hearing, which is, I do believe it's going to be June, that Wednesday. That would be June 25th would be the next hearing. June 25th will be the next hearing, as we heard. I wanted to wait until that audio came through, even though there was no visual. They had cut the feed. But as we heard, the judge did not, Judge Sharon Cruz did not actually make her decision yet. She's going to take all the information and get back within the month. So we'll either hear in her putting out an order before or at the next hearing on June 25th, what the status is. But, it really depends, because if they actually eliminate these state prosecutors, we have to assign it to a whole another area and go forward with the charges and actually have a restart. I mean, there have been so many delays in this case back and forth. The actual laptop incident has delayed it drastically. There's been multiple hearings that have been, stalled and delayed, motion to motion. Both the prosecutor who had access to the documents in question, to the information in question, he has recused himself from the case. That was Cahill Quinn. That happened in March after Judge Cruz's ruling that he could be deposed and questioned under oath in regards to what he learned in regards to the iCloud information. The defense is going to try to do whatever they can to, get the best, fairest trial that they can to move the case along, hoping for some type of dismissal. It's obviously not enough to dismiss the whole case, but all they're asking is for the whole state prosecution team from Miami-Dade that had access to the files, whether they looked at them or not, and do have still that prosecutor working in the office, to be removed from the case totally and have it reassigned elsewhere. Not really unreasonable. He tried to say it without saying it, that it doesn't matter what the prosecutor, Cahill Quinn, we don't know for sure. Now, I think that doesn't go too kindly, because these are professionals. Prosecutors are not going to willingly violate the law. They could lose their licenses. There are great repercussions in regards to this. I don't see them doing anything like that. But he kind of insinuated that because they could all talk in the office and that he still was there with the assistant DA, Sean Aberhoff, and with Miss Kathleen Hogue, the other assistant ADA, who are in charge of the cases and Sean Aberhoff is back. He was on the case and he had left and Cahill Quinn came in and now Cahill Quinn has recused. So now Sean Aberhoff is back. They all, work together and all. So there is some concern there. And I do know that Judge Cruz really sided on the side of attorney-client privilege because as it was, the Miami-Dade State Attorney's Office did not know that the parents were in communication with Courtney Clenny's attorneys per se, or that they had counsel. They had hired them for counsel to represent them in the case. They did before Courtney was actually, they were dealing with the attorneys to get attorneys for Courtney's parents in this case. And so they weren't aware of any of that when they got this information. And so, opening up emails and things like that they found on the laptop, they don't know what they're actually going to come across. So, but then they did. And then, didn't the defense have a point when they said, well, we sent you multiple letters about it and you didn't answer? That kind of struck me. I was surprised by that. That does not look good on the prosecution's end. That when the defense had a concern that attorney-client privilege was violated, they got no answer whatsoever. And not just once, but twice. And I think that's going to be a deciding point for Judge Cruz. It would be extraordinary. But then again, it's going to delay things from going to appeal and having things overturned. No judge likes to have things overturned. And, the goal is she has to balance it between the rights of the victim's family and the states representing the people for prosecution for a crime against Courtney Clenny and her right to defend herself and to get a fair trial. Absolutely the fairest trial she can get. And is there going to be some kind of bias here? Is there going to be some kind of prejudicial information that was received and shared? So even though the file's all locked up, it's kind of like locking the gate after the horse is already out. So I can see they have a point. On that, catch me on my next update. I usually do true crime and legal updates on Tuesday nights around anytime between 7 and 9 p.m. Eastern Standard Time. If you haven't already, like, share, and subscribe. And if you turn on that bell, you'll get notifications to know when I go live again to cover this case and many other cases that we're doing. On that, have a good night.